Judiciary to order. Welcome members for coming another subcommittee hearing. We don't have a lot today, so we'll try to move things right along and get you out of here. Clerk, please take the attendance.
I was thinking about budget. I forgot. I have to do this. Chair Wilson.
Present.
Representatives Weiss.
Here.
Brixey.
Here.
Menser. Morgan. Leitner. Cabot.
Here.
Shooting.
Thank you, Clerk. We will go straight into testimony. We have our guest here, so thankful for Jonathan Sachs, our director, and Marilena David, our deputy director of the Michigan State Appellate Defender Office. Go ahead and make your presentation.
Thank you. Thank you very much, Chair Wilson, Majority Representative Brixey, and Representative Cabot. Thanks for having us. Representative Metzler as well. I'll talk today about the State Appellate Defender Office and specifically about our budget asks, and through that framework we'll discuss what has been going on at SATO and what has been going on also in MAX, the Michigan Appellate Assigned Counsel System. Thank you to Marilena for joining me today, our Deputy Director, and I also want to thank the folks of the Supreme Court who've been working with us throughout this process. The State Court Administrator, Tom Boyd, Legal Counsel, Lisa Moon, and the Budget Officer there, Casey Harrell. So with that, as folks may know, I start all my presentations with the Sixth Amendment. That is where we come from as an office, the right to counsel on appeal to make sure the poor people get attorneys who appeal their convictions. So a lot has been going on at the State Appellate Defender Office. I'd like to show these headlines from our website in January. One of our colleagues was appointed to the Michigan Court of Appeals. We had a client, I'll talk about her more in a few minutes, Crystal Mulheron, who was exonerated, and also the decision that the cases that we've been working on involving 18-year-olds involving mandatory life without parole has been expanded to all 18-year-olds. So this is some of what our website is talking about there. This is where we are as an office right now in 2024. And our main two divisions are SATO, of course, the Public Defender Division, and MAX, the Assigned Counsel Division. SATO takes on about 25% of pending appeals, and MAX takes on the other 75%. And we'll talk today about some of the different units, Project Reentry, the Criminal Defense Resource Center, and the rest of the Public Defense Division and what's been going on at the Michigan Assigned Counsel System. So we have 4 state budget priorities this year, and I'm pleased to say that all of them are reflected in this year's executive recommendation. And I'll go through each in turn, and in turn talk about what's been going on at SATO as we discuss them. The first is shifting a youth defense position at MAX from an expiring Department of Justice grant to our general fund. The second is implement recommendations for the entire judicial branch from the IRS that converts certain contracts to state employees. The third is implementing a new collective bargaining agreement that includes competitive and fair wages for our staff. And the final recommendation is to implement appellate defender workload standards set by the National Center for State Courts. And this is the major of the 4 recommendations. I'll start talking about the first one, the MAX youth defense position. This is one FTE, a total of $157,000. And as I said, we're pleased to see that it was part of the executive recommendation. So youth defense is going to be a new part of the appellate defender system, but we've started getting ready for that with the Department of Justice grant. The Department of Justice grant recognized that when it comes to appeals, there have been no youth appeals from the delinquency system, and we implemented this grant a few years ago, and it has been implemented by a staffer at the Michigan Appellate Assigned Counsel System. He has done trainings, he has put together court rule proposals for the assignment of counsel on appeal, and he has been a resource on youth appeals. This allowed us to get ahead of the new amendments to the Appellate Defender Act that expanded SATO to include youth defense starting this October. And thank you, Chair and other members who sponsored and...
Can you make sure your microphone's turned on?
Sorry about that. Thank you. who sponsored and co-sponsored. Normally, folks can generally hear me, but it helps. Who sponsored and co-sponsored that legislation. So we're bringing on a few SATO positions in fiscal year 24 to get going with that expansion. But what we don't have money for, because the Department of Justice grant is expiring, is that one max position. And as with adult appeals, the youth appeals will be split between SATO and max, and to properly implement them, that position does need to be a permanent position. The second priority, I'll turn it over to my colleague to talk about.
Everybody. The second budget priority here is a large part of a larger budget ask with the combined full judiciary, and this ask is to implement something that came out of an IRS audit last year. So the IRS conducted an audit last year of a number of state of Michigan contracts, and the question being, are these contractors a little too close to full-time employees? And that would be a concern. Luckily, there were no negative findings with the contractors that the State Appellate Defender uses, but it was a good wake-up call for us that this is something that we really should consider asking for in terms of having these contractors that we use over and over and over again actually a part of our full-time budget. We're asking for 3.5 positions there at $390,000. 3 of those positions would be research attorneys for our Criminal Defense Resource Center. Our Criminal Defense Resource Center has been a part of our agency for nearly 50 years, since almost the entire time that we've existed. And this branch of our office educates the defense bar by putting on lots of trainings and publishing lots of resources and having databases for expert witnesses and brief banks and things like that for the defense community, and also for people inside of Michigan's prisons too. Judges and prosecutors also have access to some of our resources too, as well as the Department of Corrections probation employees. Here we have just a little snapshot of the things that the Criminal Defense Resource Center is doing. Last year we offered over 90 hours of complimentary continuing legal education credit for attorneys all over the state of Michigan, and published a number of resources that have up-to-date case law on all sorts of topics that defense practitioners need. So this is a really big part of what SATO does for the defense community. We've been doing it for a number of years. We also have a very robust training archive on our website. As you all know, the MIDC requires attorneys to take a certain number of CLE credit, and our website hosts a large portion of the training videos that attorneys could have access to get CLE credit. We have right now about over 1,800 subscribers through throughout the state of Michigan. Many of them it's part of the compliance plan for the MIDC training is to subscribe to CDRC's resources so that they can get the training and education they need. I also mentioned that we do offer our resources to the Department of Corrections, jails, incarcerated people. This is just a really nice message we got from an MDOC librarian who was really thankful for our CDRC manager going to do an online Zoom session for them about how to use all of the resources that are available to them. So educating the community is a very big part of what the Criminal Defense Resource Center does. These full-time employees would allow us to continue updating all of these publications that we update every single year, and maintain all of the databases that the criminal defense community relies on.
So with that, I'll move on to the third priority, and this is implementation of a new collective bargaining agreement that we have at the State Appellate Defender Office to basically to fix what have been salary issues that we've had for really for my entire institutional memory at SATO. And there are 2 pieces here. There's $856,100 for the collective bargaining agreement, and then $205,600 are parallel increases for non-represented employees. Here is the negotiating team from the UAW. We finished up the collective bargaining agreement last summer, and it was approved by our Appellate Defender Commission and by the UAW in the fall. So across the board, our salaries are at 95% of comparable civil service positions. There have been a number of reasons for this that have developed over decades and decades, but it's where we are now. We've been able to slowly raise that amount. It used to be about 87% 5 or 6 years or 7 or 8 years ago, but it's now 95%. The collective bargaining agreement fixes that. No longer will attorneys from our office be paid at 95% of what a comparable attorney general is paid for the state of Michigan, for example. And that's across the board for all staff. Everybody's at 95%. That's how we've been operating as an agency. The second piece is we compress our attorney salary scale from 15 to 11 yearly step increases. We've had 15 step increases really, again, for decades. It's been a way that we've maintained being operational, and that's been fine, but it is not a good strategy to keep our attorneys in the office. 15 steps is just too many steps to achieve the highest salary levels, especially when the job description at year 11 is no different to the job description at year 15 for a typical assistant defender. So we implement that compressed pay scale there. Our starting salaries now with MIDC reforms are less than comparable public defender salaries in Kent County, Macomb County, Oakland County, Ottawa, Washtenaw, and Wayne counties. So this fixes that dynamic. The fourth and the final budget ask, and again, this is included in the executive recommendation, is the major one. It's 23 FTEs, $3.259 million, and it's implementing an appellate defender workload standard set by the National Center for State Courts. So I'm going to talk for a few minutes about public defense workloads and specifically appellate defense workloads. The National Public Defense Workload Study came out at the end of, at fall of last year. It looked at all of the United States and public defender workloads and basically concluded that public defenders were overwhelmed. The result was no attention for clients, violation of ethic rules, and an unreliable justice system. Thankfully, in Michigan, at the trial level, there's a good framework for responding to this issue. The Michigan Indigent Defense Commission has a minimum standard that involves workloads. That minimum standard has been approved by the Department of Licensing and Regulatory Affairs, and all local systems are putting together plans, and I know the fiscal year 25 budget includes payment of those plans to resolve trial defender workloads. Appellate defenders have similar issues, but we're not part of that framework. We asked the National Center for State Courts to do a workload assessment of what appellate defense workloads look like. That took place in 2022 and 2023. And the main conclusions from that assessment was that our current model for what appellate defense workload should be is 40 years old and depends on obsolete case weights. Our current standards were 26.4 appeals per year. That translates into about 45 hours per case. That was reduced by the Appellate Defender Commission to 21.6 per year because of a workload crisis at SATO. But ultimately, the National Center for State Courts concluded it should be about 90 hours per appeal, 14.8 weighted cases per year, and that SATO attorneys now working significantly in excess of current workload expectations. We figured that out, and the National Center for State Courts figured that out through 16 weeks of timekeeping by all our attorneys of 10-minute increments, and then putting together findings based on that timekeeping, and then a Delphi panel, a panel of experts to then evaluate the results of that timekeeping. I want to talk very quickly about why that is. Why are appellate caseloads so overwhelming? So a few of the reasons are the same as in the trial system. There's been such an increase in the use of forensic science in appeals and in review of that evidence. There's also been such an increase in digital discovery. There's a shot here of a body cam video, and for the first time over the last 5 or 6 years, this is a standard part of appeals to review all this evidence. These are our colleagues in the Michigan Supreme Court. At SATO, when I started many years ago, we'd have 1 or 2 cases a term in the Michigan Supreme Court. It would be a very big deal and a great opportunity for our office and our colleagues. Now we have 15 to 25 cases per year in the Michigan Supreme Court. This is an extraordinary achievement for our office, and we accomplish great things, we think, in terms of advancing the law there, but it is a ton more work for our lawyers. It's a result, one hand, I think, of our advocacy, but also the Supreme Court has been taking on more of what are called mini oral arguments. The appeals process in Michigan, and it's talked about in this article, thinking outside the four corners, includes both trial work and appellate work. We go to trial courts as part of our appeals for resentencing hearings. We present mitigation at those hearings, and we also present new evidence at those hearings. If there's new investigations that present new evidence or new expert witnesses that need to testify about an appeal, that is not standard in other states where the appellate system is just the appellate courts. All those dynamics have created those sort of findings that I mentioned from the National Center for State Courts that talk about how overwhelmed our office is and our lawyers are with appellate workloads. So we've put together a multi-year plan, and Plan 1 is what we see in the governor's recommendation. It's 23 FTEs and includes 8 attorneys, 1 managing attorney, 3 investigators, 3 mitigation specialists, 3 paralegals and a paralegal team lead, 2 reentry specialists, a case coordinator, and an IT technician. And this way, the office is able to grow and our attorneys are able to grow to take on what should be workable appellate workloads. And it's an ask that, for SATO, it's significant, but in the scheme of the public defense system and the MIDC request for implementing workload standards is a drop in the bucket there. So we think it makes a lot of sense for the proper practice and proper response to appellate workloads. The rest of our presentation, we're going to talk about the impact of this investment, why it matters. Why it matters in terms of savings to the state of Michigan, increased morale and retention, a reduction in max roster workloads, highest quality client representation for more clients, and successful reentry and safer communities. So starting with savings to the state of Michigan. 2023 was a typical year for SATO. We reduced 193 years of sentences for the people we represented through our advocacy. And we see this as years of lives for our clients. They're releases from the Department of Corrections of years they shouldn't spend there. But we also translate that into state of Michigan savings. Each of those years is over $45,000 in bed space for the Department of Corrections pays. And we calculate that as $8.7 million. That means that the advocacy that we do almost pays for the entire state appellate defender office in our budgets. Increased morale and retention. I mentioned this also in the framework of salaries in the collective bargaining agreement. Over the last few years, we've lost more mid-level and starting attorneys from voluntary departures than in the previous years. And that is purely, we think, a result of those two dynamics, the salary dynamic that will be fixed through the collective bargaining agreement and the workload dynamic that the National Center for State Courts shed light on. The quote here is a survey that we did when we were looking for bidders to do that workload study, and it's a typical attorney at SATO talking about how hard the work is and how much they enjoy and appreciate the work, but how that work has ultimately been overwhelming. Decreased reduction in max roster workloads. So the workload isn't just for our public defenders. We found in 2023 that 22 roster attorneys had workloads higher than SATO standards. The National Center for State Courts found the max does not have caseload caps, and some private roster attorneys carry caseloads which greatly exceed SATO's current caseload standards. And part of increasing our direct appeals staff isn't just to decrease their workload, it's also to take more appeals in. And the increase that we're looking at for this year will allow for 75 new trial appeals or 200 new plea appeals per year to SATO. This hopefully means we take the pressure off the 75% of the 75% of other appeals that are handled by that roster of 110 private attorneys, some of whom have workloads that are too high. The reduction in max roster workloads, we've hopefully already started this year. I want to thank this committee for their support and talk a little about our implementation of the new fee policy. So all circuit courts have now adopted new uniform fee policies for the max roster that match Michigan Indigent Defense Commission rates. There have been over $1.5 million in county investments to make this work, and now starting this fiscal year, we have a state one-to-one match to pay attorneys at reasonable rates. So we've been implementing that, and that's been working out. It means over 10,000 vouchers of meaningful performance and cost data to analyze, and more efficient assignment and voucher processes. The goal is ultimately the roster is more attractive for more lawyers to join, and we get smaller workloads and better accountability that way. But in the interim, increasing SATO's direct appeals will decrease pressure on the roster. I want to quickly talk about some of the other things we've accomplished on the private roster side. We have enhanced training, robust litigation support, sentencing mitigation support, client reentry services, confidential client video visits the roster attorneys can use, discounted legal research tools, and comprehensive performance reviews. In particular, we now have a max mitigation specialist who is grant funded. She has represented 40 clients working with 26 roster attorneys. She's a social worker and has accomplished more than 77 years in sentencing reductions for those clients. One trial court judge talked about how helpful that work was for that process. The fourth dynamic here is the highest quality representation for more clients, and we intend for that to continue to grow with a larger direct appeals unit. This slide shows the partner of our client, Crystal Mulheron, along with his representation team. That's our latest exoneration. Crystal Mulheron was convicted for shooting at somebody from a bicycle, a very serious offense. She was convicted based on a identification that raised some questions and based on what we now know is false testimony from somebody who shared a jail cell with her. Our wrongful conviction unit, working with the Genesee County prosecutor, was able to do a DNA test on the handlebars of that bicycle, and they found that that DNA matched the DNA of a cigarette butt that was discarded near where the shooting took place that was somebody else, that actually is somebody else who we believe the Genesee County prosecutor's office is now investigating. At the time of trial, there were no DNA results for the handlebar, and the prosecutor was able to argue in good faith that, look, yes, there's a cigarette butt with someone else's DNA, but that wasn't the shooter. The shooter was somebody else on a bike. We found that to be completely incorrect, and our client, Crystal Mulheron, has now been exonerated of that shooting. More recently, less recently, I talked about our Michigan Supreme Court advocacy, and the recent case of Joshua Stewart is one that talked about a coerced confession. He was 18 years old. He received false promises of leniency from the police who interviewed him, and racially charged language during that interview. And the Michigan Supreme Court found that was a coerced confession, and as a result, there's more looking at coerced confessions and problematic confessions in our work. The final piece we'll talk about the impact of the investment is successful reentry in safer communities, and I'll turn that over again to my colleague for that.
Thank you. The work that we do does support successful reentry in safer communities. I think it's something like 95% of the people that are in our prisons are going to come home and be our neighbors one day. And so we're cognizant of that with the work that we're doing in reversing people's convictions and getting new trials and getting people resentenced and in front of the parole board. And in 2016, we launched Project Reentry at our office with absolutely no funds, all volunteer work, all interns. And we did it because we recognized the importance with the juvenile lifer population we took on in 2016, that these individuals were 15, 16, 17 going inside, and they're 50 years old coming home. And they had no support and no idea what was needed. And so we realized very quickly that reentry support was necessary for the juvenile litigation that we were doing. And this is a photograph of the reentry community at a summer gathering that we have every year. What we have also learned in the years of doing this work, especially with the juvenile lifer population, is how important community support is, and to have other people going through the system and experiencing similar things as you. We've also heard from judges and prosecutors how important reentry planning is for their decision making. Some prosecutors want to know before they decide what sentence they're seeking, well, what's the plan, right? Does he have anywhere to go after all these years? What's going to happen? And so our Project Reentry team that is now funded through our general fund has been over the years helping people create reentry plans, helping them with their first days home, and we have found that the first days home are some of the most important days. Actually, these are photographs from our juvenile lifer unit and Project Reentry team with our clients in their first minutes home after coming home from prison. Again, it's so important to make sure that they're set up for success when they come home. We want to make sure they know how to get to their parole board meeting with their, their parole agent, their meeting, and making sure that they're doing everything that they're supposed to do when they come out of the community. Our juvenile lifer unit now has 7 attorneys, 6 mitigation specialists, 2 reentry specialists, and 1 paralegal. It's a small team doing a ton of work and representing a ton of people, and they've been doing excellent work since the launch of that unit in 2016. For for that unit and the work that's been going on in our juvenile lifer unit, it's been focused on children 17 and under. And we have represented about 177 people to a term of years resentencing, meaning they went from a life without parole sentence to a term of years where the parole board would then be able to determine if they're ready to come home. We've had 42 contested Miller hearings, and those are hearings where the prosecutor is seeking life without parole and where basically the judge has to decide if that's an appropriate sentence or if a term of years is an appropriate sentence. Out of those cases, we've had 9 that did result in a life without parole sentence again, and already about 5 or 6 of those have actually already been reversed on appeal, finding that those outcomes of life without parole were invalid under the law. We've welcomed home about 85 of Michigan's juvenile lifers, and I can say, as somebody who manages our Project Reentry team, I can say with certainty that Michigan's juvenile lifers are some of the best people I know in terms of what they've accomplished, what they've overcome, and what they're doing now in the community to make things right and to make things better for the future. So it gives me a lot of hope. It gives our team a lot of hope that the folks we're bringing home through this advocacy are really making a positive impact on the community. There are still about 13 of those individuals awaiting the resentencing, and so those are individuals that will be going to either to Miller hearings or to term of year sentencings very soon. In our Project Reentry team does a lot, not just reentry planning, but we also hold community workshops in our office space. It's one of the programs that the Department of Corrections supports as a pro-social activity for people on parole to come together, come to our workshops. We have workshops on how to use technology, how to build credit, how to set goals and achieve goals on your taxes, all sorts of things like that, just basic things that people who are incarcerated might not know how to do. We do bring people into our office for those workshops, and we also publish a lot of resources on our website for returning citizens and formerly incarcerated people in the community, and that's all accessible to everyone online. Michigan's standard recidivism rate is something about 22.1%, which I think is the lowest it's been in a while. And the juvenile lifer recidivism rate is significantly and remarkably lower over the years. And so this is based on the data the Department of Corrections has. And I have pictured here a picture and a news article from Lorenzo Harrell, who is a reentry specialist at our office and is also a former juvenile lifer who served 26 years in prison. He's been home for about 5 years now. NPR did a story on him and his success and life. And again, his story is amazing, but it's also a story that we see lots of juvenile lifers who are coming home having this type of success back in the community when they're there. We do have upcoming litigation now happening, so some additional litigation aside from that 17 and under group. There was a case last year in the Michigan Supreme Court, People versus Parks, that held that mandatory life without parole sentences for 18-year-olds is unconstitutional in Michigan. And on January 18th of this year, the Court of Appeals held that decision was retroactive. And so now there are about a little over 260 people serving life without parole sentences for crimes committed as 18-year-olds. And now those individuals are entitled to resentencing. Our juvenile lifer unit is in the process right now of getting all of those folks appointments. Not all of them, but a significant number of them will end up representing about 170 of those individuals. There was also a case where the individuals that were serving parolable life as 17 and under are now entitled to resentencing. That was People versus Stovall. And there are about 77 people in Michigan that are now eligible for those resentencings. And again, our office is representing some of those, as are some of the local defenders as well. And we don't expect it really to stop there based on the advocacy that's happening in these cases, and also consistent with the adolescent brain development science. It says that all of these things pertaining to 17 and 18 and under individuals also pertains to people through their mid-20s. And so now there's litigation in our Supreme Court for 19 and 20-year-olds and whether they're also entitled to resentencing after serving a mandatory life without parole sentence. And I also just want to make clear that Life without parole is still a sentence judges can impose, as you saw from one of the previous slides. It's just it can't be mandatory, and it has to be after a consideration of what we call the Miller factors and circumstances of the individual's youth. So that's what we're doing in our juvenile lifer unit and our Project Reentry.
Thank you very much. This last slide is a series of awards we won last year, our lawyers and our core staff for different work, ranging from Project Reentry to Best Brief to an organization that empowers women to one of the managing attorneys recognized as one of the 2023 Women in the Law. And with that, we would be pleased to take any questions at all.
Thank you for your presentation. Just wanted to go back to what you were saying about current litigation. What is that? Is that already at the Supreme Court level? And when do you expect a ruling on that?
The current litigation that we have here, we already had a ruling for the 18-year-olds serving mandatory life without parole. So those
The 19 and 20-year-olds.
Oh, the 19 to 20-year-olds, those are pending in the Michigan Supreme Court, and we don't know what the timeline could be. It could be any day we hear that the court has interest, or it could be a year from now.
Okay. Is there a particular case? Is there a name?
Yeah.
That they're
Zarnecki is the lead 19-year-old case.
Okay.
Is his name.
Thank you for that. And then, based on that, how soon after the ruling would SATO need to start taking up those cases, and how would that impact your budget if that ruling comes out?
It would be similar to the process we're going through now with 18-year-olds. Last year, we anticipated the issue with 18-year-olds, and that was a major part of our fiscal year 24 budget, was the growth of the juvenile lifer unit for that work. And it depends on the timeline. If the Supreme Court takes the Zarnecki case sometime in the next year, you'll hear from us sitting here next year about what we anticipate. For 19 and 20-year-olds, it's comparable. I don't want to give exact numbers because I'm not completely confident, but I know we took a look at Department of Corrections data, and it's comparable to 18-year-olds, probably about 300 or so 19-year-olds, 300 or so 20-year-olds. I know we looked at 19 to 21-year-olds, and it was about 1,000 for those three age groups. At least now for 21-year-olds, the Supreme Court does not seem to be taking an interest, but for 19 and 20-year-olds, we know it's a possibility, and depending on the timing and how many 18-year-olds remain to be resentenced, we might seek new growth in our juvenile lifer unit if that does happen.
Okay, thank you. We have questions from committee members. Rep. Cavett.
Thank you, Chair. Thank you for the presentation. It was very informative. There was a term, holistic representation. I'm just not familiar with that. Could you explain what holistic representation means?
Sure.
It was on slide number 26 is
Yep.
where I saw it.
It's what we try to accomplish for representing our clients big picture rather than just what is the basic appeal. So when Marilena talks about Project Reentry, that's what we see as holistic representation. If somebody is going to be going home and our juvenile lifer unit is making a case for a term of years for them, we want to be able to say, look, judge, and look, prosecutor, we're working with on this sentencing. Here is where he would live, and here's what his job would look like. It's also why we have a social worker, both for Max and SATO, working with our clients on new sentencing hearings and what those look like.
Okay, thank you. That makes sense to me.
All right, are there any other questions from committee members? Seeing none, thank you both for coming for your presentation today, and look forward to continuing to work with you throughout this process.
Thank you.
Thank you very much. And our contact information is in the material if anyone would like to reach out or any other follow-ups.
All right. Continuing on our agenda, Representative Brixey moves to adopt the minutes from our subcommittee meeting held on February 14th, 2024. Hearing no objection, the minutes are adopted. Seeing no other business today, Rep. Morgan moves to excuse absent members. Hearing no objection, the motion is adopted. Hope I give you enough time back on your day today. Enjoy the rest of your day. And this subcommittee meeting is adjourned.